The next session is being hosted by Skadden. The topic is Focus on Client In-House Counsel's Roles and Expectations for the Arbitral Process. I would like to call upon Ms. Sharmishta to introduce the panel. Thank you.
Good morning, everybody. And a huge thank you to the MCIA for organizing India ADR Week. As I was telling Neeti Sachdeva earlier, she does a wonderful job, and I don't know how she does it across 3 cities and many, many panels every single day. I have the distinct honor today to introduce Skadden's panel. I have visiting with me my dear friend and partner, Mr. Gregory Litt. Greg, although based in New York, has extensive India experience. He was one of the lead partners on the Tata Docomo arbitration, which many people in this room must be familiar with. Right next to him is Dr. Akhil Prasad. Dr. Prasad is a board member and the group general counsel and company secretary for all the Boeing India entities. He's also on the board of directors for all of the Boeing India entities. Dr. Prasad, thank you so much for joining our panel and for agreeing to share your experiences with you. Right adjacent to him is Mr. Amber Gupta. Mr. Gupta has 25 years of experience and he's the head legal of the National Stock Exchange. Again, needless to say, I don't need to introduce the NSE to this crowd, but given his role, he oversees all of the litigations and arbitrations at the NSE. And last but not the least is Mr. Ravi Mahto. I'll first say Ravi is a friend, and I thank him so much for agreeing to come here and speak today. Ravi is with Tata Sons and in their group legal team. And he and I have spent many nights discussing arbitration clauses and provisions. So I said, Ravi, you are the perfect person to come here and share your experiences with this group. With that said, I'll leave it to Greg to moderate this panel, and I'm looking forward to lively debate. Thank you all.
Thank you so much, Sharmista. It's really a pleasure to be here. First of all, just to be in Mumbai, which is such an exciting and vibrant city, and to be at this conference. And I really do have to thank Sharmista, who has been at this conference in years past and has been urging me to come. And it was great advice. It's been so great to see so many friends and to meet so many new people. And it's a delight to be here with you and with this really terrific panel. I'd like to get a sense before we start of who we're speaking to. I see some familiar faces and some new faces. So I'm going to ask for a little bit of audience participation just to get us started. I'm going to ask you a few questions, and we don't have time to go around the room, but maybe with a show of hands, if you can give us a sense of who we're having this conversation with. Can I get a show of hands of who in the room is based here in Mumbai, who primarily here in the city of Mumbai? Okay, great, thank you. And who is based in other parts of India? All right, thank you for coming. And who is here from outside of India? Okay, so it's unscientifically, it's a kind of evenly split between Mumbai, the rest of India, and the rest of the world. So that's great. We can have a really nice conversation. Let me ask another question that well, maybe a little indelicate, but I'm not actually asking you your age, but just to get a sense of people's relationship to the world of arbitration. Raise your hand if you were involved in the world of arbitration at the time the Supreme Court rendered its decision in the Balco case. It's about 2012. Okay, a few, but a lot of people who have come to it over the last 10 to 15 years. And I think that's why I think that's great. And it's why we gather at these conferences, because we want to learn from the people who have experience and the people who are thinking about the things that are important to our practices. I've been in a practice of international arbitration for about almost 25 years. I'm based in New York. I've worked with Sharmista for many, many years in international arbitration, and we've had the great opportunity to do a lot of work with India. Sharmista mentioned the Docomo Tata case, where we were actually on the non-Indian side of that case, but we've also represented many Indian companies over the years. And it's been fascinating to watch the development of the field of arbitration in India over the last 25 years. There have been so many important milestones and changes, both in terms of commercial arbitration and the relationship between the courts in India and the world of arbitration, and also, though I think we'll talk about it less today, in the investor state world, where there have been very important cases, some of which Sharmista has been involved in over the years, involving the Republic of India in BIT cases. And we've watched as they have increased, and then India has pulled out of investment treaties. So they may perhaps have decreased, and now there's a thought that India may be re-engaging in various kinds of investment treaties. So it's another interesting aspect of our world. Today, what we'd like to do, especially for those of us who are in private practice, and I've been in private practice my entire career, is we'd like to get a little insight from the people who hire us, from the people who make the decisions for their companies about what type of engagement with the world of arbitration to have, how to have that engagement, and when to bring in outside counsel for their assistance and their help in achieving goals in the world of arbitration. And so we're very, very fortunate to have a panel of senior in-house lawyers with us today. They're from 3 different kinds of companies. I think you've already heard. Akhil is runs legal for Boeing India, which is, of course, the Indian arm of a foreign company. Ravi works for Tata Sons, which is one of the most storied indigenous Indian companies that is famous to everyone around the world. And then Amber works in a very different kind of company, working for the National Stock Exchange. So we have a very interesting array of experiences. And I should tell you, having gotten a chance to talk with the 3 of them, each of them has a different type of career path and a different type of interaction with the world of arbitration. And so we're all coming at this from different perspectives. And so what I'd like to do at the start is just ask each of our panelists to say a few words about their own career path and about how their career has led them to have interactions with the world of arbitration. Yeah.
Thank you, Ravi, for a wonderful introduction, and thank you, Skadden and MCIA for the opportunity. So I'm fairly young in the profession, just 30 years of experience, and I have I've been fortunate that out of those 30 years, I've been mostly working for American companies. Arbitration, what I have seen in the 3 decades is India has really transformed, especially the international outlook towards India on arbitration. 30 years ago, perhaps there was a lot of talk about why arbitration should not be held in India and how complex or bad it is to do arbitrations in India. So last 30 years, and especially the last 10 to 15 years, have been really transformative, especially because of the very important role that the Apex Court of India, which is the Supreme Court, has played in terms of recognizing the importance of foreign arbitrations and why they should be honored. The foreign arbitrations should be honored in India. So that has been a sea change. As a general counsel, my own experience has been, which may not be good news for the practicing counsel or the external counsels in this room, is to avoid arbitration. Because the focus, if you look at us as a business, we sell defense products to the Ministry of Defense, where the arbitration clauses are typically seated in India, although with ICC rules, and that's a government procurement requirement. For our commercial plane sales, arbitration is not the solution. It is usually the courts in the United States because the point of sale is the United States. On both these aspects, the questions that were asked to us is whether we should resist the MOD to insist on having arbitrations in India. So I must say that, our job was to first convince our global legal teams to tell them why arbitration is perfectly okay if we do it in India. And, although, there are some challenges there on the kind of the quality of arbitrators that we have. I'm not saying people tend to say the retired judges, but I'm not putting a blame on the retired judges because it is more about individuals than it is about a category of people who are arbitrators. But things are definitely, they have changed, and there's a lot of scope of improvement for future, which means that we should have more arbitral bodies like MCIA and others. And of course, we need to have an institutional process in India where the international arbitration agencies also should, and this is what we've heard from the government, that international arbitration forum should also have a substantive presence in India. And that is only the way how the Indian ecosystem on arbitration is going to improve. So a lot of work is being done. I think a lot of improvement also will be in the horizon. This is my opening thought.
Thank you. Let me ask you one question
Yeah.
before we move on. You said that you had to do work in maybe in your current role or maybe in other companies where you've worked to help make the sort of foreign companies, U.S. companies you've worked for, comfortable having arbitrations seated in India, as opposed to having the venue exclusively outside of India. Can you tell us a little bit about what that work entailed and what were the kinds of questions that they had that you needed to answer?
So primarily the question was whether we have good capability arbitrators. And that was an easy one for us to answer, because the kind of talent we have in terms of the external counsels in this country who can advise you on arbitration, it was not a difficult thing. I think people were more worried about the involvement of the Indian courts in on the finality of a foreign award. So that is where they were mostly concerned, and which over the period of years, the judgment from the Supreme Courts have definitely helped us, because the courts are now very reluctant in terms of interfering in the finality of the or the implementation of a foreign award. Uh, the other thing was the quality of arbitrators, which I think I'm repeating myself, but that was a major concern from our Western counterparts.
And when you well, let me stop there, and I'll have more questions. But let's get the rest of our panelists involved. Maybe go to Amber, and if you wouldn't mind telling us a little bit about your path and work, which is a little different and interesting.
Good morning, everyone, and thank you, Skadden and MCI, for giving this opportunity. I was personally very excited to see that this time not one but two sessions are focused on in-house counsels. So that's a great change which we are seeing, and that also indicates the importance of the in-house counsels when it comes to managing the arbitration process, because we as a user actually are the people who day in day out are managing the entire process along with counsel, and we have to manage the cost, the timeline, update the board, keep making disclosures in the stock exchanges also, because now under SEBI regulations, which is a capital market regulator, any dispute is there, you have to make a disclosure if it is above the materiality threshold, and key updates also has to be keep given. So thank you for this session. And as a user, as a professional in last 25 years, ADR, particularly arbitration, has always been an area of interest for me. And that is the reason that I also a couple of years back completed my fellow from Chartered Institute of Arbitrators. Very few in-house counsels have been able to complete this, and thanks to MCI and Niti, which managed this process, and we were the first batch to do it from Mumbai. I will go back a little bit in history and taking you what Akhil just mentioned about court interventions. And I will go back in 2012 when the Balco judgment was announced. And I think that was the first time there was so much of international attention which was given to the Indian arbitration, which it overturned the earlier Bhatia judgment, which we all aware about part 1 and part 2. And when the Balco judgment specifically overruled and said no, the part 1 only applies for domestic arbitration, and part 2 will continue to apply for international arbitration. And there's no specifically requirement to exclude part 2 while we are drafting the arbitration clause. So I think as an in-house that was also a good relief which we thought and bring a lot of clarity. And what has happened after that, when we are negotiating arbitration clauses with international parties, we are able to also explain them, that you also will have ability to seek interim relief, without excluding and specifically mentioning about Part 9. It's a default that you can also seek those relief. So that's the time when actually I also getting more attracted to arbitration and the ADR mechanism, and more so the fact that it is based on a unsettled model law, which is adopted by almost 180 countries, which gives a kind of a uniformity in the manner in which the courts are interpreting about venue versus seat, about jurisdiction, about conflict of laws, about the arbitrator qualification, conflict of interest, their competence principles, manner of enforcement, public policy. So all those things which are there are universally applied, whether you are doing an arbitration in India or in Singapore or in London or whatever seated. If you are part of unsettled model law, a signatory to that, New York Convention. So that gives a lot of certainty, clarity, and also gives you an edge in terms of how you want to approach an arbitration when it comes. So the processes remain same. There is a consistency. Most of the rules of international arbitration, arbitral tribunals and the institutions, whether it's LCI, ICC or MCI, more or less they are in similar when it comes to manner in which the arbitration process is to be done, the timelines which are involved. Of course, cost-wise there might be some differences, but so far when it comes to the procedure and other things, there is a lot of similarity. So I think that way it gives a lot of, if you are doing an international arbitration, if you are doing agreements with international parties, the knowledge of arbitration as in-house and with these developments which have been there really gives a lot of advantage to you in the current scenario when we negotiate contracts. As a user, of course, there have been various experiences in terms of the challenges which we face, whether in terms of managing cost, getting the good quality, or ensuring that the arbitration procedures are completed within timelines. With domestic, of course, the Arbitration Act has now amended in 2015 amendment, which allowed certain timelines within which the entire arbitration process has to be completed. So those things are very, very positive when it comes. I work for a national stock exchange. We have our own mechanism of dealing with arbitrational dispute, resolving of dispute between broker and a client or a shareholder or a listed entity, and these have been given a special statute under Indian law. So earlier we had the entire arbitration process was managed by the stock exchange itself. We had our own rules, we had our own timelines within it. The award has to be passed, which it is like a mini institutional arbitration which is managed through the national stock exchange. Of course, 2 years back, SEBI, our capital market regulator, made a path-breaking announcement of ODR mechanism. So again, capital markets were the first to adopt the ODR mechanism, where all the disputes will be resolved through an online dispute mechanism, through the empowerment of ODR Institute and exchange playing the pivotal role in terms of anchoring the entire process. Now this kind of process is now being also replicated by other sector regulators and for timely disposal of disputes or small values without getting into too much in evidence part, which is most probably a document-led evidence arbitration. So these are my opening remarks, and maybe we'll cover more in the second round. Yeah.
Thank you very much. Let me ask you a question. You were talking early on about the Balco decision and the distinctions between Part 1 and Part 2 of the Arbitration Act as it was at that time, and how the Supreme Court made a clear distinction between domestic arbitrations and international arbitrations. Now, obviously, that's many years ago, and there have been amendments to the Arbitration Act, and there have been a lot of other precedents. But sitting here today in 2025, from an in-house perspective, how do you view differently domestic Indian arbitrations and international arbitrations, and do you have a different appetite for the use of arbitration in domestic matters versus international matters?
Yes, of course. So, as we all know, the most important factor when an arbitration award is passed is all about enforcement, right? The two other important factors is, of course, time and cost and the enforcement part. So I think recently in one of the cases which has happened for the first time 2 years back, where Indian courts have also given recognition to appointment of emergency arbitrator by the SEAC, under SEAC, and it was fully enforced by Indian courts. So these are some of the development which has happened recently. Then how even the and that was a interesting case where both the parties were Indian, right? The arbitration was seated in Singapore. They got the emergency award, emergency arbitrator. That was challenged in India, and the court upheld that they have full right for the appointment of emergency arbitrator for two Indian parties for a foreign seated arbitration. So these are a very important development. Also on the issue of public policy, which always been a major concern, right? And there have been recent very judgments where courts have also held that in the matter of international arbitration, the public policy element is to be seen very in a limited phase.
Yeah.
Especially if your assets and recovery proceedings are to be done outside India. Compared to domestic arbitration, in case of domestic arbitration, the scope of arguments of challenging the award under public policy is much wider compared to international arbitration, and there has been some judgment by Supreme Court of India where they have ruled this kind of precedents. So these are two important aspects which I feel are positive and giving definitely a change of mindset, which Akhil also mentioned in his opening remarks. So these are two considerations we will look at it. Of course, the overall aspects of what you call as efficiency in the entire process, that also creates a lot of importance when it comes to looking at the domestic versus international arbitration. As an in-house, based on my own experiences, and no offense to any of the people who are sitting here, currently when it comes to domestic, there is still a lot of focus to go for ad hoc rather than choosing institutional arbitration like MCIA or any other institutional. But when it comes to international arbitration, people are still preferring for institutional-led arbitration process. So that's the distinction which is also there.
Do you have a personal view about that for ad hoc versus institutional arbitration for domestic cases?
All my views are personal. If the word is recording, so those should not get quoted as an exchange, anyways. My own experiences. Yeah, definitely. See, because my own experience is that when I'm negotiating large contracts, when I'm negotiating large contracts which involves shareholders, right, which involves large contract values, where confidentiality is very, very critical for me, my preference will be still to go for institutional arbitration because of process efficiencies, because the manner in which the secretariat run the process, even the way they also ensure that timelines are met. But for other aspects which are non so critical, my preference will be still to go for ad hoc, because you can also manage not the manage, at least you can have more say in terms of process. There is more flexibility compared to institutional arbitration where the flexibility is very limited. But the confidentiality and all those things takes precedent. So based on that, a different set of contracts which are there, or different set of clients which are there, those strategies has to be applied with.
Thank you. That's great. Let me stop you there. I want to bring in Ravi. And Ravi, you have a somewhat different path because you've been both at some of India's top law firms, and then also now in one of India's most famous companies in-house. But you come at it as a transactional lawyer and not as a disputes lawyer. And so I'd be interested to hear where arbitration has come up in your practice, and as fundamentally a transactional lawyer, what you think of this world of arbitration.
Thank you, Greg. And thank you, Sharmishta, for inviting me on this. Pleasure to be part of this panel, and pleasure to be here in this room. You are right. So I don't have so much of a disputes experience, so to speak of. I was a transactional lawyer earlier, so I negotiated clauses, arbitration clauses. At times, they were treated as boilerplate clauses. But my view, as when I came in-house, and probably it's the legacy of Tata Docomo which we acted on, we don't treat arbitration clauses or negotiating arbitration clauses anymore just as a boilerplate. We do a lot of stress test. We do a lot of scenario mapping of how things will play out, even how the substantive provisions will play out in an arbitration. So yes, I haven't seen disputes, but like we anticipate. A lot of my work is anticipatory, and it's a rigorous exercise the way we have done in a number of transactions which we are working right now. So it's not easy. It requires so without having a facts and ground, you are mapping out, so you are looking at many more hypothetical situations probably than what would actually transpire. And to cover for all of that, it's not an easy task. But I think that is the way to go. And as the maybe other organizations, when they actually face real life situations, they will also inculcate this practice. I think it's important. What we also do is like when we are doing a transaction, in addition to say M&A lawyers, we get the disputes lawyer involved upfront in the drafting to do that testing. It's not limited to the M&A lawyers, and that is a very, when they ask, of course we are willing, and at times it's our own ask that okay, please get this stress tested by a disputes lawyer. So a lot of this is what I echo with what Akhil and Amber has been saying. The evolution of arbitration law gives a lot of confidence. Maybe it's not perfect. There is still some difference between the sophisticated, the more arbitration friendly and sophisticated jurisdiction as compared to India. But I think we will get there. And we'll also start looking at probably India as a viable arbitration venue and institutional arbitration in India. Because when I always hear that, okay, there's differentiation when it comes to domestic arbitration, the differentiation between ad hoc and institutional arbitration. Like there is a particular choice, there is a cost difference. But kind of transactions which we are doing, at least at Tata sense level, maybe it might be a concerns at operating companies level when you have recurring contracts, but at least for us, we are doing that evaluation that okay, whether institutional arbitration works for us or not. We are testing that, we are checking with our lawyers that okay, there could be other factors also like okay, which arbitration in India itself is better, whether the Delhi is a better jurisdiction, because it also comes to how the courts in those states are looking at arbitration, how arbitration friendly those courts are. So we are evaluating, and as an opportunity arises, at least at Tata sense level, we are looking at institutional arbitration now.
And so when you say you're looking at institutional arbitration, you mean including for domestic
including for domestic,
cases,
and
as
of
a
course for
preference.
outside, it's always institutional.
And I know you haven't been at Tata Sons for your whole life, but based on what you see there, do you think there's been a change in their view? Has that evolved? Did they previously use ad hoc and have shifted, or has that always been their practice?
Certainly, even earlier, so we don't do a lot of these ad hoc arbitration. We didn't do because it was generally we had a counterparty who was coming from a different country. So in those cases, it's difficult to push for ad hoc arbitration.
Yes.
But in terms of approaching that institutional arbitration framework itself, there is more debate going into it. Which is a better institution, whether cost is important in a particular case or not, whether interim relief is important in a particular case or not. So we are mapping scenarios that, okay, what is our need out of this contract? What is it that we are commercially trying to achieve out of this? And whether the arbitration framework will support it or not eventually. So,
Yeah.
If you allow me to
Sure,
add,
of course.
So I was negotiating a very large shareholder deal a couple of years back. And it's a large deal in my previous company. We were trying to buy out one insurance company. It was a 100% cash deal. We had two prominent law firms representing we as buyers and the other side as a seller. And when it came for negotiation of the dispute resolution clause, I suggested for institutional arbitration for MCI. To my shock and my surprise, both the law firms opposed that, and they said, no, we will go for ad hoc arbitration, we will not go for institutional arbitration. That was about 7 years back. And when I came and I told the Niti also, and I gave their law firm's name also. I said, I think you need to talk to them rather than, reaching out to in-house counsel. You have to also tell your law firms also that when it comes to, they should accept that. And the reason which I got was very funny, which was got. And they said that same thing, that in ad hoc arbitration, we will be in a position to more have flexibility in terms of managing the entire arbitration process. Of course, that was 7 years back when the entire concept of institutional arbitration in India was still growing, and things have changed now. But some of these experiences have been there when even as an in-house you might like to push for institutional arbitration, parties may continue to push for ad hoc.
Yeah.
So for aviation industry, as I said, for the MOD requirements is to have an institutional arbitration. But the kind of industry we are, the aviation industry, the supply chain is huge. And if you manufacture a plane, you need parts and components from 180 countries. And so it's very, to have an ad hoc arbitration perhaps is a non-starter, at least in our industry.
So I'd like to shift to a question that I think is on the minds of many people here in the room, and we will try to save some time to get their actual questions, but I'm going to predict that this is one of their questions, which is I'd like to get a sense from each of you about when you decide to involve outside counsel, because you're all in companies with extremely capable in-house counsel who seem to know quite a lot about the field. So when do you decide to instruct outside counsel in connection with arbitration, either at the transactional level or when a dispute is arising? And then since we have a mix of local and foreign practitioners, why don't we also talk about when you decide to instruct Indian counsel and when you decide it's also worthwhile to bring in an international firm? Yeah.
Sure. So I think I briefly touched upon this, Greg. So the involvement, we are not averse to bounce our thoughts with our external counsels. We might have our views, we will look at a particular clause, we know what we want. But what's helped is like use our external counsels as a sounding board. So we would use them. And all depends also on the stakes involved and the value of the transaction. Of course, there are those variables. But as a matter of approach, we would like a discussion at the time of stage of drafting. When we foresee that, okay, a particular situation may turn contentious eventually, we would take that view. There would be, the final path, eventual path can be very different. It can be sorted out commercially. But from our perspective, when advice is sought from us that, okay, how do you see ourselves placed in this particular situation legally if things don't turn out as well? Then then we need a particular answer. And that's where, and a realistic answer. So it's not just a theoretical answer, but it has to be a realistic answer. So the more brains we put to it, it's better for us, considering the stakes which might be involved. So we do involve transaction lawyers, we involve disputes lawyer at the stage of drafting. And also, like, eventually as things progress, we would like to get our lawyers involved at an early stage.
Thank you.
There's no one-size-fits-all answer for this particular question, and it really depends on the nature of transaction, the type of agreement, the parties which are involved, the nature of disputes, likely dispute that can happen. Of course, if it is a matter of a transaction, for example, I mentioned there is a buyout, there is a share purchase agreement, then of course the involvement of external counsels are much high. When it comes to even drafting of the arbitration clause or negotiation of the arbitration clause or the dispute resolution clause which happens. In case of potential disputes which is likely to happen, again, in my own experiences, where the parties involved are of international stature, there is always a push to seek external advice at an early stage to anticipate, because my own experience, international companies, especially based out of US, they are try to keep a lot of documentations through emails which can be used later on as an evidence to prove their statement of claim. So most of their emails and notices of disputes or even early pre-dispute notices are vetted and drafted by their counsels, compared to in India where most of the things come to counsel at much later, when dispute has already reached to differences have already reached to a stage that now it has come to invoke the dispute resolution clause and send notice of arbitration. My own experience, when you deal with the international parties, they tend to involve these kinds of vettings and reviews quite early, the moment there is some difference have started between the parties. So if it is the international parties and if you are getting these kinds of notices or any likelihood of potential disputes, my advice would be definitely to get an early references of your own for external counsels who can also help you in drafting proper replies, more so from evidence perspective later on, because some of these emails, in my own experience, later on becomes difficult to defend and explain when it comes to evidence stage.
So I agree with Amber because there is no one size fit all. Especially for our sales contracts, we don't go to external counsel because usually it's a global template for selling an aircraft, and the dispute resolution will be in the US. Even for the Ministry of Defense, wherever you sell to Ministry of Defense, whether India or wherever, it's all governed by the procurement policy of that country. So there also you do not perhaps involve external counsel because it's a part of the procurement policy of a country where the arbitration would be held. But when you are supposedly Boeing is doing something new in the country, for example, if we are doing services contract with Ministry of Defense, that is where you will be negotiating that new contract with the Ministry of Defense for servicing whether a Apache or a Chinook or a P-8 or a C-17. That is where there is definitely a requirement of working with the external counsel on the contract, especially the dispute resolution. Or if you are doing a joint venture for implementing certain projects in country, whether it's a JV with Tata for manufacture of aerostructures for Apache, that's where Tata Sons and Boeing Law Department will sit together, of course, with their respective external counsel support and negotiate on an arbitration clause. So for our industry, anything which is international, perhaps the involvement of external counsel would be less because the documents contracting is very, very standardized. But if there is something new and upcoming for the aviation industry to do some new things in India, that's where external counsel is relied upon.
Okay, and that's on the drafting side. How about on the dispute side? When when you see something's maybe not going right, what's the moment?
Yeah, so the moment typically is, whenever you have to seek an advice on the what the other party is claiming from you. So how good is the claim?
Yeah.
So I think the importance of an external counsel advice will be to validate those kind of things, which usually starts with a typical sales team not seeing eye to eye. They're sending you some harsh emails. So you go back to the external counsel with some facts and data, which doesn't come to you often, unless there is an arbitration notice. Only then teams start to sit together and really claim. But the discussion with the external counsel, I would put a red flag the moment you think that the discussions are not going in the right direction. So my approach personally, has been, and thanks to the networking that we do in India with all GCs, most of them are friends. So if you are facing a big problem, the first thing is better to talk to the GC of the other party. And most often than not, in my so many years, I have seen that works very, very well. That if you are facing a problem with the supplier, go to the supplier GC, and then the person understands your point of view, and you tend to break the ice with their business teams through the GC. And that's how we've been able to resolve a lot many issues. If that doesn't work, then you need a specialist, the go-to doctor, which is you, and then involve your firm to validate the claim of the other party.
Right.
Yeah, that's how I've been doing it and avoiding disputes.
Yeah, that makes sense. And either want to comment on that?
No, I think.
Sorry, carry on, please. So, Akhil, I understand, like, okay, when, say, it's your contract, so you don't need to go to external advisors while drafting it. You know what the implication of those clauses are.
Yeah.
But what's your experience with your counterparties? Like, even if it's non-negotiable, and I think that's the position which Boeing would take, at least it also helps in understanding what they're getting into, right? So, wouldn't your counterparty at least involve external lawyers then?
Yes, of course, that happens.
So,
it happened to us when we were negotiating the Akasha deal. It was Denton's Indian Link Legal. And, this was peak of COVID. 400,000 cases in US, 400,000 cases in India. I was asked to, at a 2 days notice, I was asked to go to US because our contracts team in the US were not able to convince Link Legal's questions. And that is where, the power. So they brought in Link Legal, which was Akasha. And here was still, the external counsel was not brought in by Boeing. It was Boeing's legal team which was discussing or negotiating with Akasha's external counsel, which was Link Legal. So we did not press the panic button because there was no panic. It was customer. So customer brought its counsel. We did not.
Yeah.
Yeah.
Well, and that probably works for you very well because I think as Ravi was sort of implying, you're doing the same deal over and over again, but the customer, for the customer, it may seem new.
So
Absolutely.
yeah. So it also has a flavor of the territorial jurisdiction where this contract is being negotiated. In my own experience, if you are negotiating contracts, say with a counterparty which is in Europe, they tend to more rely on the external counsel at a very early stage, even at the drafting, compared to when you negotiate a contract with somebody sitting in a pure UK outside Europe or American party that ways. Because recently I was negotiating a contract with a German counterparty, and their counsels were very much pushing for certain clauses, and it was taking advices on that. Even though I was trying to explain how these clauses will not work in India. So when it reaches to a particular stalemate, then for giving comfort to management, sometimes it is also important that you may seek an external help and bring a third eye perspective to close the issue in the interest of to go ahead with the transaction. Either ways, whatever be, the management will take the final decision, but always get that third perspective, a neutral one, look at it and do a risk assessment in terms of validated rather risk assessment, more of a validation by a third party, so that at least contracts get closed and business starts.
I must give you one more example. So, when you are negotiating contracts, especially with government, so they somehow take an offense that lawyers are in the room. It may sound very odd to you, because I think it sounded very odd to our US attorneys. And, they have been pushing me, why don't you go into the negotiation with MOD? And the sensitivity here is that if you are going to a discussion with MOD on a contract, MOD will not bring in Ministry of Law. And the moment you say that our Boeing's counsel wants to come, they said they don't like it. And they said, we do not want lawyers in the room. So that also depends on the kind of negotiation you're doing.
Yeah. Does that include you, or is that only with external counsel?
No, it's both of us. so the MOD, the government of India typically, because their process is such, it's so robust that when they are negotiating, I think the negotiating team has all kind of authority.
Yeah.
Because they are working on their contract and they will not accept any deviation. But if you insist on a deviation, they will tell you that we will have to go to the Ministry of Law. And they will not appreciate having lawyers in the room, which is both the in-house and the external.
Yeah, I've encountered a lot of people who didn't want lawyers in the room over the years, but we do what we can. Okay, well, I want to shift gears a little bit to back to the discussion of who arbitrators are, because it came up before, sort of the importance of assuring foreign businesses and parent companies and so forth that there are high quality arbitrators in India and you know how to find them. There are many high quality arbitrators in India. But I'd be interested in hearing from each of you, to the extent you can share what you're looking for in arbitrators. What in your mind, what are those qualifications? How do you find those people? What are the indicia of an arbitrator being the kind of person you'd like to see on your tribunals?
Yeah. So I think this topic was also touched upon in the previous session about the entire appointment of arbitrator. So I'll take further from that what was discussed in the last session. At least from, for example, the overall experience, the credibility, all those things are of course very important when you are looking for an appointment of arbitrator. And again, it has to be seen whether it's an ad hoc versus an institutional arbitration, right? If you have an ad hoc arbitrator, you will again have a more say in terms of whom you want to recommend an arbitrator. And again, if it's a if it's a sole arbitrator, then in India typically it's always Section 11. I mean, court intervention is needed, because whatever name of arbitrator you might be proposing, the other party always reject that. Ultimately, it goes to the court. And personally, I am very hoping and very bullish on the amendment on the Arbitration Act that the entire administrative procedure for appointment of arbitrators is now handed over to arbitral institutes, so that court's time are not wasted on that. So that is one part of it. Of course, if it is a three arbitrator, then you don't find that kind of issue much, because both the parties have a right to nominate one arbitrator each, and the two of them will appoint a third arbitrator. But definitely, in my own experience, domain expertise is something which is very important, because it saves a lot of time. Currently, I'm also handling one a software dispute related arbitration, and we are definitely finding that thing that most of the arbitrators who are retired judges, they have a difficulty in understanding how the entire software contract works, right? So in my own personal this thing, domain expertise is very, very important. It makes the entire thing very easy. It makes the process easy. If you have an arbitrator who understands the subject matter, then of course it saves a lot of time when parties are making frivolous arguments, or they are trying to bring witnesses which are not required, by some time and all those areas. I am not aware of other jurisdiction, but at least in India, the Arbitration Act, when it got amended in 2015, it has also prescribed, who can be an arbitrator. So they have given certain illustrative list of qualification, like somebody, an advocate with 10 years of experience, somebody who is accredited by an international certification agencies. Those things are good reference point which you can take. There is also a tendency, and when it comes to, of course, the institutional arbitration, then you give that authority as per the process to the arbitration, the institutional arbitration to recommend, and then you can choose from that list. But second thing which is very interesting and important to also note, that in there is also a tendency to prescribe the qualification of the arbitrator in the arbitration clause itself. Uh, some people prefer that approach to ensure that there is more certainty in terms of what kind of arbitrator they would like to have. They prescribe those qualifications. But to me, I think it may not be a best strategy, because flexibility is gone. So if you are unable to get that kind of arbitrator, then you keep delaying the start of the arbitral proceeding. So better not to prescribe those kind of qualification in your clause itself. Keep it open, and of course, during the appointment stage, you can bring those perspective also. Yeah.
Okay. And Ravi, when you're working on clauses and you're putting together agreements, how much do you pay attention in the language there to prescribing the qualifications for arbitrators?
See, aspects like qualifications, experience, and all is a given. Like, we don't prescribe, well, just to answer to your question, we don't prescribe the qualifications typically. We would rely on a standard, more or less standard format arbitration clauses from whichever arbitral institution we are looking at. We prefer not to tweak them much, except as maybe strictly required to suit our requirement. We wouldn't tinker much with the process. But in terms of selection, just to respond to the question earlier, in addition to the technical qualifications, legal experience, we have come to realize that power of persuasiveness is quite important, and it comes from our learning from real life cases. Like, it's important that the arbitrator who we are going for is able to persuade the entire panel, and to what extent, with his own expertise and view. It does matter, because ultimately there would be one chairman in a three-member panel. So we are looking at, that's the decisive vote in a way, and that's where it's not only about what you have, but it's also how you, the capability of an arbitrator to persuade the entire panel becomes important, and we do keep that in mind.
Oh, great. Thank you. And we'll round it out with Akhil. Do you have thoughts on appointment of arbitrators, how you pick them?
Yeah, so, as I said in my opening thing, that, in India, still the retired judges seems to be the most preferred as a choice of arbitrator. But the development area is that I want to see more professionals coming into arbitration, because people who have experience, let's talk about in-house counsel. The kind of experience an in-house counsel would have on the business commercial aspects makes that person the ideal fit to be an arbitrator, especially for that industry. Um, Three industries are on this panel. So if each one of us get that certification what Amber has, and then we are appointed as an arbitrator, I think we can do fairly good justice. But the problem is, it's about the game of chess. So arbitration is a game of chess, and you have to see what kind of game the other person is playing. If the person is putting on a very senior retired judge, perhaps the risk appetite for the company to have a general counsel as an arbitrator, perhaps is the risk appetite is very low. And then you have to match a heavyweight with a heavyweight, and that's how it tends to be. You have to see what the other party is proposing as an arbitrator, and then your organization will ask the GC, what do you think? So obviously, that risk becomes too great to digest.
Just to add that now, after Parkinson judgment, in India, which has now earlier what used to happen that, especially in government contracts, and Akhil would have more experience on that, when you deal with some government or PSUs who have their own panel of arbitrators, and within that you have to appoint. And this has been actually taken a very severe beating from the courts, and they have said that any such mechanism where one party is appointing an arbitrator from its own panel of arbitrators, this is something which is not which seen as a fair process. It is seen as somebody that is not a proper way of appointment of an arbitrator. So that happened more importantly in one of the important judgment in Parkinson's, where the entire issue of unilateral appointment of arbitrator by certain banks and NBFCs who used to appoint their own set of impaneled arbitrator, and the other party has to accept it. That has something which has become a challenge when it comes to enforcement, and courts have ruled in favor of that. And recently in Bombay High Court, 2 weeks last month, a very important judgment was delivered by Mr. Somashekaran. He was the earlier counsel, and he's elevated to the judge last year. And even he has pointed out even the manner in which the ODR institutes are appointing arbitrator from their own panel. That he has also expressed in unhappiness and not in compliance with the Arbitration Act. And the direction has been issued to them to explain how their process works, to ensure that there is fairness in the appointment of arbitrator. There is no conflict of interest which are involved. So some of these elements has to be keep into mind, and especially, for example, in financial services sector, after these two judgments have come, after especially Parkinson's judgment, all the banks and NBFC, they have changed their arbitration clause to ensure that there is no such challenge when the appointment of arbitrator happens, especially after the award has been passed. So you have to, as an in-house, you have to be also keep that in mind. And a couple of years back, there was another NBFC company. So what used to happen that NBFC companies used to have a lot of recovery proceedings, and they used to appoint the same arbitrator in 200, 850, 300 cases. And the matter went into Bombay High Court. The Bombay High Court called the GC of that particular NBFC company. I don't want to name that company, a very reputed company, NBFC company. And he was reprimanded that how you are appointing the same arbitrator in so many cases. And the technical, the usual argument was that it is with the consent of the parties. But the other side of the parties were retail individuals who may not have much say on the appointment of arbitrator. And that become very important case law also. And so some of this development which is happening are also creating a good precedent and bringing more neutrality in the manner in which the arbitrators are appointed, apart from, of course, other aspect of qualification, experience, domain expertise and all.
It's interesting. Thank you. Okay, we have about 7 minutes left, so I want to take a pause and see if there are any questions from the room. We'll take 1 or 2 questions.
Do we have the option to skip very difficult questions?
Yeah. Well, they'll come to me first, and I can reject or accept them. So behave.
Can you hear me?
Yes. Tell everyone who you are and where you're from before you
Sure.
ask your question.
My name is Mantul Bajpayee. I am working with the disputes resolution team of the law firm Crawford Bailey and Co. My question, any one of the speakers can take. Now, as in-house counsels, I often wonder what is that deciding factor which, which plays in your mind when it comes to settling the dispute or fight it out in court. I mean, as external counsel, we can obviously give you an advice, but what really goes on in your mind when you actually decide to settle it out or fight it out in court?
आप बोलो पहले as a
Yeah.
senior.
Yeah, this is a big issue for Akhil. So let's.
Actually, you hijacked that question because it was. Anyways, I was going to ask that
It's
question.
a perfect question.
So I can give you my thoughts. It's the unreasonable. If the other party is very unreasonable, and you are not able to break the ice, so the steps are several before you decide to take them to arbitration. I think there's a lot of work that needs to be done as an in-house counsel. The first thing is get the right people on table. So more often than not, it's an ego issue between the heads of the commercial head or a business head of two different organizations. And that ego issue gets passed on to the lawyers. So the first thing that you have to do is to try and kill that ego and try to bring them on table. Then you need to have a good connect with the other party's general counsel. And the general counsel should understand the point of view whether you have to then try and break the ice. And then you see how you can negotiate further to bring down or come to a reasonable settlement. If it is not happening, then the only option is to go to arbitration. That's how I see it.
Do you want to give an example?
There are several, in fact. In my 12 years with Boeing, we have not even let one arbitration go forward, and we have been able to settle a lot of these kind of issues. One example I can give you. So this was, we purchased a lot of component parts and from India as a part of our offset commitment. And one of the offset commitment was to purchase aluminium from Hindalco. And then Hindalco, unfortunately, got sanctioned. They were issued CBI warrants for the coal scam. And the warrants were issued against the former Prime Minister, the CEO of Hindalco, the Hindalco company because of coal scam. And then we had a big contract with them. So it did have those FCPA provisions and things like those. We were on an offsite in Japan. Our global GC was there, and he called me and he asked me what should you do. So it's a clear FCPA issue, and should we terminate the contract, and it will result into arbitration. So he asked for my view as an in-house counsel. What should we do? And there was the entire legal team who was trying to put pressure that yes, it's a FCPA, things like those CBI involvement and all that. But my view was that we should not terminate the contract. And my rationale for that was, number one, we are not buying coal, we are buying aluminium. And the coal scam has not been decided. It's just at the very, very preliminary stage. Only the summons have been issued. Hindalco is a very respected organization. And there has been no directive from any court not to buy aluminium. So how can you just on the basis of a summon by a CBI court terminate a contractual relationship at the pretext of FCPA? Nothing has been proved. And that is how we avoided arbitration. And the other thing, there are several examples. I can give you one more. So Apache helicopters come with a warranty of 10,000 feet. And the highest battleground, it's a global warranty, 10,000 feet. And the highest battleground is Siachen. And the minimum height is 13,000 feet. Leh is at 13,000 feet and above. So the question was whether the warranty is void. The answer was no. And we had to find a way because our contract said the warranty is void and we cannot guarantee that the helicopter would be in an operational state at Siachen. So we found a way, we installed another starter unit. That was a simple fix. And that solution, a dumb question from me came that why can't we have an additional starter switch? And everybody said, yes, that can be done. And that's how we resolved the conflict. And the phones were coming from PMO. That how can you say that there is a warranty is expired? So almost on a daily basis, we face situations like these. And the question is, talk to other person's counsel, have a dialogue with them, break the ice, avoid egos. If you avoid egos, I think you can simplify a lot of legal work. That's how we have done in the past.
If I may add to that, so merits of the case aside, like what Akhil was saying, one thing what would differentiate an in-house lawyer's view on when to settle is probably the reputational risk which might come out of the ongoing proceeding. I appreciate that arbitration might be confidential, but there is always a risk of what may come out, and eventually it may go into courts. So that's an additional factor beyond the merits, beyond the dynamics which you have, which we also which we need to keep in mind, particularly in an organization like ours, where reputation is of paramount importance.
Okay, I think we have time for one more question. Okay, maybe over here. Can we get the microphone is coming?
I'm Pinky Bansali. I'm an arbitrator and I'm also a cybersecurity expert. So my question to the panel, including the moderator, is in light of recent High Court judgments, what do you think as we as Team India are available and are in that sense capable of coming to the situation where we finish the arbitration in a time-bound process? And as a general counsels, what are the difficulties that you see is coming in getting this thing accomplished?
So, so I couldn't hear properly. As in-house counsel, sorry?
Am I okay now?
Yeah.
Am I audible?
Yeah.
Yeah. So, in view of recent reforms, where the court has given a thing that we should, move more towards a time-bound accomplishment of the arbitration proceedings. As general counsels, what do you think are the difficulties that we all face as arbitrators, as general counsels, etc., to achieve at that timeline where today we are seeing 1.5 year and going to a situation where we are able to accomplish this, maybe wrap it up in a month or so time?
Yeah. So my take is that most of the delays typically we see are in ad hoc arbitration. So the solution definitely lies that if you move towards institutional arbitration, where the process is well governed, there is secretariat with manages. At the very first day itself, the entire timelines are set. Somebody is monitoring. Severe costs are also imposed if there are delays, etc. So if those things are begin as more of an adaptable form, we would like to see less delays compared to ad hoc, because in India currently most of these arbitrations which are delayed are majorly ad hoc, and most of the cases that you go which are challenged and all those things are mainly in ad hoc arbitration. Now even in the Arbitration Act, now there is a 18 months timeline which has been already given, which is further clarified that it will be initially from the filing of the statement of claim, and now it is after the conclusion of the pleading. So there is a timeline which is given. Of course, it can be extended with the consent of the parties and with the court intervention after 2 subsequent extensions. So if their intention, and if you compare to international arbitration, I have never heard during my conversation in my own experience there are any delays. So these timelines are pretty much set and everybody adheres to that. In fact, they sit for a complete 10 days together and complete the entire process of evidence, leading, witness, cross-examination, everything is over. So move towards this institutional-led arbitration. I think this entire delays part can be curtailed. Yeah, that's my take. I mean, the panelists can, and you can also add. Now we have got a chance to speak.
No, that's okay.
You can share your international experience.
They're here to hear from you. I mean, I think from the international perspective, it really requires the good faith of everyone involved, because there are processes and there are tactics, and so I think we all know that when we're as outside counsel, when we're in a dispute, the most important thing is trying to help our client achieve their goals. Yeah. And if I'm honest, sometimes helping our client achieve their goals means slowing things down.
Possible.
And so your emphasis on institutional arbitration, I think, is important, because then you have a more firm grasp on what the rules are and what the processes are and how it will be managed. And so I think if we want arbitration to stay on track on a policy level, then I think we have to put those structures in place, because when we're in the dispute, if you're my client and you say I need this to take 6 months longer, I will do everything I can to make sure that it does.
I think, just to add, and that's the beauty of the arbitration, because party autonomy is everything, and That's the people try to prefer an arbitration to some extent, and at least they are in the process to control some of the process. Not control, at least they are in a position to make that request and allow those flexibility a lot. And I've seen ad hoc there's more problematic in terms of unending timelines, delays, or adjournments, which sometimes may become irritating if you have a good case.
Yeah.
If you have a good case, and there are guerrilla tactics which definitely most of the the respondents also use it if they feel it's not a good case. And I'm not talking about litigation funders at all. If they get involved, then the matters can go in a totally a different way if they have a serious take in the outcome from the arbitration. I'm leaving aside that part. But I feel what I feel is that over a period of time, when I was recently talking to a few people who are practitioners in arbitration, and just to add one other aspect, that after these strict timelines have come under the Indian Arbitration Act, all those arbitration which has started after this amendment, majority of them are getting closed within 2 years time, 18 months to 2 year time, because there is a timeline. Courts also are not very reluctant to give extension after 1 or 2. So they are very particular. So those arbitration which was started prior to this amendment and these timelines, they continue to still drag on, because those timeline requirements are applicable prospectively, not retrospectively. But those which have started after that, there has been a very positive move in terms of completing in timelines.
Yeah. Okay. Any final? Okay. Well, we're beyond time's up. So I want to first of all say a big thank you to our 3 panelists. It was a really great discussion. It's great to have people with this level of experience and thoughtfulness, frankly, to discuss these issues. And even though we're gonna stop the panel because there's a big screen blaring times up at me that you can't see. I encourage you all to get to know them if you can, and come up with your further questions, and to continue the conversation. So thank you again to my partner Sharmista Chakrabarti, who put this together for us, and also to the MCIA for holding such a wonderful event. And thank you all for being here.
Thank you, Greg.